I'd like to call the meeting to order, please. Roll call.
Swigert.
Here.
Tallman.
Here.
Baker.
Here.
Russo.
Here.
Vandergast.
Here.
Before we start, I'd like to read a short statement about the role of the Board of Adjustment. The Board of Adjustment is a quasi-judicial body created by the City of Iowa City according to state statutes. The Board's purpose is to decide on applications for variances from the zoning ordinance, appeals of decisions of city officials, and applications for special exceptions requested under the zoning ordinance. Board of Adjustment is an independent volunteer board made up of Iowa City residents and is not part of the city administration. We're assisted in our work by the city attorney's office and by planning staff. Prior to this meeting, board members received the materials submitted by the applicants, the staff reports reviewing the application, and any correspondence submitted by members of the public. Board members have not discussed the application or its merits with each other, staff, the applicant, or any other member of the public in advance of this meeting. All consideration and discussion by the board takes place in open meeting here tonight, where we will also have an opportunity to hear from the public. Board bases its decisions on facts and evidence allowed by city code presented in open meeting. Concise and truthful testimony helps us a great deal in our decision making. We ask that if you wish to speak, that you come to the podium, print your name and address on the sign-in sheet, and speak clearly into the microphone so your testimony can be heard by all present and by our minute taker as all testimony becomes part of the public record. We ask that the proceedings be orderly and that when you are testifying, you address your remarks to the board. If this meeting becomes lengthy, we may ask that testimony be focused on new facts or on information not already presented. The order of proceedings for each application will be an oral report by staff summarizing the issues of the case and staff's recommendations. An opportunity for the applicant to speak, an opportunity for any other interested parties to speak for or against the application, an opportunity for final statements and arguments by the applicant and staff, and then the board will discuss the issues and evidence, state its findings, and vote on a motion. Motions are always made in the affirmative. First item on the agenda is variance item VAR 26-0001, an application requesting an area variance for the expansion of a non-conforming drinking establishment in a CB10 Central Business Zone for the property of 18.5 South Clinton Street. And before we start the discussion, we've got a short statement by the attorney.
I hope it will be short, Mr. Chair. One thing that I wanted to draw the board's attention to is that the application for a variance tonight is by way of a provision of state law. It's Iowa Chapter 414.12 that was given effect by the state legislature in July of last year. That provision allows for as I printed it out and set a copy of it before you. Before July of last year, it had 3 numbered items. Now it has 4. And so what you're here tonight to consider is the application of the facts presented here to your powers and duties under number 4, plus any other duties that may be afforded to you. So as you alluded to, you are the board is a creation of the ordinance of the statutes or the ordinance of the city of Iowa City, and so you have the powers that are given to you by this document in front of you, and any additional powers that may exist in the city code. My understanding is that the city code for Iowa City has not been updated to reflect this particular change in state law, and so what you have in here in front of you in number 4 is going to be the applicable standard to apply. That being said, this is a new law. There's not any case law that has been decided on how this applies to various facts, and I want to suggest that the board include in its deliberation tonight, a threshold question of whether the application here before you is something that falls within one of these 4 items, or specifically item number 4, whether you have subject matter jurisdiction to consider this variance. And so I would invite I would suggest the board invite the parties to speak to whether this is the appropriate vehicle for the question that's being asked by the applicant. I'm happy to discuss further, and I don't want to sidetrack your proceedings, but I do think that there needs to be a threshold question of what are we here for? Does the board have the power to grant the relief being requested.
And that's a question you want us to ask both of the staff and of the applicant.
I think that would be appropriate so that they have a chance to respond to that. I've given them just a brief heads up that I would be asking them a question about that and to speak to that matter. And I have my own thoughts, and I'm happy to advise you when we get there. But I wanted to have them to have an opportunity to present their thoughts on that first.
Okay, great. Anything else? And you want to start with that and then do the staff report?
I guess we received an application for an area variance. We have reviewed the application and are presenting it to you. I think I think we should move forward with reviewing the application, if that's the question.
Okay.
I think, yeah, and Sue, if you want to come up, I think this is a threshold question of whether they have the ability to decide the question altogether.
Does Sue need,
Whether-
do we need
whether-
to open a public hearing first before Sue talks?
Yes, you should open the public hearing.
Okay. Public hearing is now open for this issue.
Yeah, Sue Dulick, obviously for the staff, which is why we have this conflict today. And I'll leave it to Ann, but I think what the attorney is wanting is a discussion on the issue of a non-conforming use. Can a non-conforming use be expanded at all? I mean, I think what we want to talk about is how we talked about it as staff, that can't be happening at all. That just can't be, that's not allowed. But the applicant did make a request for an area variance, and so we went through that. But I think it's the initial decision, and I think as you start your staff report, is you can't expand a non-conforming use. That's the issue.
Yeah, I guess what I would say is that, and I cover this in the staff report and we'll cover it in the presentation, but our zoning code does allow for non-conforming drinking establishments to expand. And there's two ways that it can expand. And we can get into that if you'd like. But the request that's being asked, as was mentioned in the staff report, doesn't meet those criteria. The type of expansion that's being requested is not allowed, but there are ways for non-conforming drinking establishments to expand.
Right.
Okay.
Yeah, and you're perfectly capable of going ahead and hearing everything. I wanted people to get that on the record, whether they objected to continuing under these or not, and it sounds like they're okay continuing. But
Do we need to hear the applicant express that opinion before we hear the staff report?
I think that would be wise if they wish to speak on this question, although I don't know that
All right,
that's
thank Please.
My name is Brian Roris. I'm representing Koa Cantina. I'm one of the owners. I wholeheartedly disagree with this. The same logic should apply to all patios. There's a gap in policy between just sidewalk cafes and rooftop units. We're on the second and third floor. There's nothing in between. So I fully disagree.
All right, thank you.
So the question is, do we have the authority to decide this or not?
That's the question I would pose. I think the staff is willing to.
Are you telling us that we should go ahead with the hearing with that doubt?
I think you should make a finding as to whether you have the authority to do that. I think that the code that I provided for you that's sitting in front of you has a list of remedies. And with respect to the area dimensional or other numerical limitations, not contrary to public interest, a lot of these things were covered in the staff report. Some things were not covered in the staff report that do exist in the law. One of which being that the practical difficulties that a property owner might suffer must be for making a beneficial use of the property, which is otherwise allowed by the zoning ordinance. And so if you can't, if it would be an illegal zoning end result, if that zoning is not permitted, I think that there is a question of whether number 4 here applies at all, whether this is in fact an area variance or rather a use variance. And a use variance carries with it a higher and different standard rather than a practical difficulties. It comes with hardship, unnecessary hardship, which is a much higher standard. I think that's a question that needs to be considered. Also, they've applied for a variance under number 4. I don't know that they would be able to speak to applying for a variance on number 3. That might be a heavy ask. And so I want to put this out there as something that the board has the ability to look at and consider. I think you should make a finding of whether you can or can't proceed. I think you have the power to make that call, and either way is fine.
So if a majority of this board decides that we do not have,
Then you must dismiss.
then we must dismiss how it's decided. Does this go to a separate court?
It's not decided. It's not something that you would decide. They could petition for writ of certiorari or some other equitable relief. But generally, the Iowa Supreme Court has held that enlargements or extensions of non-conforming uses are not allowed. And so that decision was made before the state enacted paragraph 4 before you. This is a tough question, and I don't have a definitive answer for you. And I think that I would encourage you to gather what information is available, and then make a decision based on what information you have available. Right?
So you want us to have the hearing and then make a decision before we have a vote?
I think there's a threshold question of, is this a question we can decide, right? And I think you should probably look at what the relief is requested, which is an area variance. I think staff could probably present and they can talk about it. But as you're making your decision, I think before you go down the list of criteria, is this good for the neighborhood? Is this, that, and the other? I think one of the factors you need to also consider is this something we have the power to decide? I think you need to add that to the metrics that you're going to consider. And I wanted to have that up front so that both of the parties could speak to that during their presentations. Is that helpful?
Okay, so that decision has to be settled before we vote, but
If it's
that decision has to come after the discussion.
It doesn't have to, but I would recommend it. I would recommend giving everybody the opportunity to speak. We're all here, we're all dressed up, and we have the time set aside. I just want to make sure that that question gets presented and considered by the board, so that in case it is answered in one way or the other, the parties have the chance to appeal that later, right? But I want it to be part of the record.
Sure. Okay, thank you. So I assume we're going to proceed with the hearing. Decide this question at some point during or at the end.
I think that staff has probably presented you with a rubric in their packet saying these are the questions you need to answer. I think in addition to those questions, one of them is, do we have the power to be doing this?
Okay. Ann, I'll turn it over to you.
Okay, thank you. Ann Russett, Neighborhood and Development Services. Let me just share my screen here. Okay, so as the chair mentioned, this is an application for an area variance for the expansion of a non-conforming drinking establishment for the property at 18.5 South Clinton Street. Here's a map of the subject property. It's located in our downtown, right across the street from the Pentecrest. And here's the zoning map. Again, it's in the downtown, so it's zone CB10, which is our central business district zone. First, I want to provide some background on this application and on the request. As I mentioned, the applicant is requesting an area variance to allow a rooftop service area. And this rooftop service area is proposed as a second-story deck addition to the rear or the east of the building. In review of this request, we've determined that this is a request for an expansion of a non-conforming drinking establishment. The reason that this is a non-conforming drinking establishment is because it's located in our university impact area, and we have rules on where drinking establishments can locate in the downtown. They must be separated by 500 feet. This drinking establishment it does not meet that 500-foot separation distance requirement, so it's non-conforming. As I had mentioned earlier, there are a couple ways that non-conforming drinking establishments are allowed by our zoning code to expand, and one of those ways is to obtain a special exception for a rooftop service area. In August of 2024, the applicant applied for a building permit and requested approval to construct a second-floor deck on the rear east of the building. Our building inspection services staff denied this permit because it was an expansion of a non-conforming drinking establishment, which is not allowed. The main reason behind this is that the deck would increase the occupancy load of the use from 170 people to 200, and that's a 17.6% increase. And based on our definition of expansion in the zoning code for non-residential buildings, an increase in the occupancy load is considered an expansion. Again, non-conforming drinking establishments can expand through getting approval for a rooftop service area. This requires a special exception, and there are multiple criteria that must be met. One of those is accessibility. It needs to include elevator service. The rooftop service area must also be located directly above and contiguous with the drinking establishment. And also there can be no horizontal expansion. And again, this is a deck that's attached to the building that horizontally extends from the building. And due to that increase in the occupancy load, it is considered an expansion. So this proposal does not meet those requirements. So just to summarize here, Koa Cantina is a non-conforming drinking establishment because it does not meet the 500-foot separation distance requirement. Non-conforming drinking establishments are limited in how they can expand. The request to add a deck to function as a rooftop service area would increase the occupancy load of the building, and that is considered an expansion per our definition in the zoning code and is not allowed. So we did receive a request for an area variance on January 7th. And as we've kind of been discussing, area variances are related to area, dimensional, and numerical provisions listed in the zoning code. As Mr. Lins said, the City Council has adopted standards for area variances that the Board of Adjustment can use, but the effective date of that ordinance is tomorrow. But we still have the state law. And so the definition, again, is relating to area, dimensional, or numerical limitations. And the examples in state law that are given are things like minimum lot sizes, setbacks, yard widths, height, bulk, sidewalks, fencing, signage, and off-street parking. So staff finds that the request does not provide relief from a zoning code provision related to area, dimensional, or other numerical limitations, that it's a request to expand a non-conforming use. But we did receive the application, so we reviewed it against the area variance criteria. Should I keep going? Okay. So here's a photograph of the subject property. And here are the plans that were submitted with the application. Again, you can, here on the left is kind of a sketch of the proposed deck with the stairs that would provide access to and egress to the rear of the building. This image here on the right kind of shows the location. And just moving forward again, I think we've already covered this. A state law recently was adopted that gives the Board of Adjustment the ability to review area variances. And so we have identified the criteria that would be consistent with state law. Again, that was adopted by council and it's effective tomorrow. And in order for the board to approve the area variance, you must find that all of these criteria, all 5 of these criteria are met. So we'll go through these one by one. The first criterion is that the proposed variance will not be contrary to the public interest. The proposed rooftop service area consists of a deck addition to the rear of the property, resulting in an expansion of the non-conforming drinking establishment, again with the increase in occupancy. Our RSAs are allowed. However, the proposal does not meet the requirements. There's no elevator. The deck obviously is not above the drinking establishment, and it does result in a horizontal expansion. And our regulations aim to avoid overconcentration of drinking establishments, particularly within the downtown. Expansion to the east would require egress to the rear of the building, which is privately owned. There's no public alley behind the building. It's a one-way in and one-way out. And based on conversations with our police department, it's not well lit. There's not great access for emergency response, and it's not visible from the street. So this image over here shows the location of the subject property. The arrow shows how you access the property from the rear off of Iowa Avenue. And again, it's the typical alley that you would see in the downtown. So staff finds that this criterion is not met. The second criterion is owing to special conditions, a literal enforcement of the code would result in practical difficulties. The building has housed a variety of retail establishments over its 150-year history. Koa Cantina began operations in this building after both the 500-foot separation distance requirement and the rooftop service area standards were adopted. Prior to Koa Cantina, other drinking establishments operated for many years in this location without an outdoor seating area. Staff finds that this criterion is not met. And number 3 is that the practical difficulties are unique to the property and not self-created. Because staff finds that criterion 2 has not been met, there are no practical difficulties in this property, and therefore criterion 3 is not met. However, assuming criteria 2 is met, that there are practical difficulties, we wanted to go through our analysis of this criterion as well. Non-conforming drinking establishments are allowed to expand if they meet the criteria of a rooftop service area. The building does not allow for the inclusion of a rooftop service area without substantial changes. There is a peaked roof on the building. But there are also other criteria that must be met. We've talked about the elevator, and we've talked about that they cannot result in a horizontal expansion. The proposal increases the occupancy of the use through a horizontal expansion of the rear deck. And per the definition of expansion, an increase in the occupancy load is considered an expansion. The Iowa Secretary of State issued a certificate of organization to Iowa City Cantina in September 2022. Iowa City Cantina became a tenant in this location around October of 2022 and obtained its first liquor license in November of 2022. And the city's regulations for rooftop service areas have been in place since 2015, and thus any practical difficulties with the property are self-created. Additionally, standards for rooftop service areas and the issuance of liquor licenses were adopted to ensure city goals regarding drinking establishments were maintained as it relates to public health and safety. Not being able to meet the standards that are required to have a rooftop service area, standards that have existed for the 7 years of Koa Cantina's existence, does not automatically mean there's a practical difficulty. So staff finds that this criterion is not met. Criterion 4 is that the spirit of the zoning code provision shall be observed. The purpose of the zoning code is to implement the city's comprehensive plan in a manner that promotes the health, safety, order, convenience, prosperity, and general welfare. In 2009, the city established the 500-foot separation distance requirement for drinking establishments, and any drinking establishments that existed prior to the adoption of that ordinance became non-conforming, and they were restricted from expanding. In 2013, that ordinance was amended and limited the separation distance requirement to the university impact area, which the subject property is in, and riverfront crossings. And the main concern here is the concentration of alcohol uses near the University of Iowa campus. And these regulations ensure safety and general welfare of the community, and allowing a non-conforming drinking establishment to expand is not aligned with the spirit of the zoning code, so staff finds that this criterion is not met. The 5th criterion is that granting the variance will not significantly alter the essence essential character of the neighborhood. The character of this area is defined by a 2 to 3 story historic block along South Clinton Street across the street from the University of Iowa campus. It includes a variety of different businesses. The proposed expansion will not be visible from the street, so in terms of the character of the downtown, it would not be impacted from an aesthetic standpoint. And as I mentioned, it does increase the occupancy by 17.6%. So since the deck would not be visible from the street, and the increase in occupancy is 17.6%, staff finds that any impacts to the character of the neighborhood would not be significant. So staff finds that this criterion is met. Staff received one piece of correspondence that was provided by Midwest One Bank that was included in your placket. Today, we received 3 additional pieces of correspondence which were forwarded to your board, to the board, and are printed out and handed out to you this evening as well. 2 letters supported the variance and 1 letter expressed concern. Staff does recommend denial of VAR 26-0001 to allow rooftop service area, which is proposed as a second-story deck addition at the rear east of the building at 18.5 South Clinton Street. And with that, I'll turn it back to the chair.
All right, thank you very much. Any questions for the staff?
I don't quite understand something here. In 2009, the legislation regarding 500-foot distances was introduced, correct?
Yes.
So in 2022.
Mark, sorry, can you use your microphone?
Oh, I'm sorry. In 2022, he apparently received a license from the city to open this, even though it was in conflict with the 500-foot rule. How does that work?
So it doesn't run with the business, it runs with the use. So over that period of time, there was always a drinking establishment in that location, so they're allowed to continue.
I see, but it's still non-conforming.
It's still non-conforming.
Any other questions for staff? And I have one brief question. There are means that a non-conforming drinking establishment can expand. Certain criteria. Has that happened recently, or can you give a couple of examples where that has happened?
The one that I'm familiar with, which was before my time with the city, was Joe's Place. Got approval for a rooftop service area.
Can you remember when that was?
Well, it would have been after 2015
Okay,
and before I started in 2018, so somewhere in there.
great. Thank you. Any other questions? If not, would like to hear from the applicant.
I have some materials I'm going to pass out to you guys so you guys can follow my PowerPoint.
Yeah. Great, thank you.
Thank you.
Thank you.
Does the applicant have materials to share with staff, and
I
so they can take a look at that too?
can happily. I have an extra one.
I would like to see one
Okay.
too, yeah.
Do I have more than one?
Oh, maybe that's for the extra one. I thought I printed out.
Oh, maybe give it.
I have another one.
Hey, thank you. Is the other item a menu?
Yeah.
Okay.
All right. Get this stuff. All right. My name's Brian Rohrs. Like I said earlier, I'm the owner of Koa Cantina, located at 18.5 South Clinton Street in downtown Iowa City. I'm here today to request a dimensional area variance under the new bill of HF 652 in order to construct a patio on the rear of our building. This request, I want to clarify, is not a use variance. Our business remains the same. We're a bar and a restaurant. I provided menus to show you that we do have a full menu. We're not just a full-out drinking establishment. We're seeking relief from dimensional restrictions due to unique physical constraints of our building in which the current code does not contemplate. Current code only addresses rooftop service areas and sidewalk cafes. So we're talking only at the ground level and the roof. So I provided a little document for you guys on the back of your sheets that show our layout. So here at the ground level, you can see it's in the code and allowed. If you go to the roof, it's also in the code and not allowed. There's nothing in between. That is a total gap in policy. Additionally, this is what area variances are for. This is a complete practical difficulty under the standards of HF 652. Due to the setup of our building, and our only option for outdoor dining is on the rear of the building. We're surrounded by multiple other bars and restaurants, and we are the only one that does not have an outdoor service area. I also included that, and it was also in the packet that was provided to you guys. We have 30 other establishments surrounding us, and we are the only one that does not have one. That is an unequal playing field all the way across the board. This denial is based on physical layout and not a change in use class. This is why we're doing an area variance. HF 652 has now been codified and goes into effect tomorrow. And it explicitly authorized the Board of Adjustments to grant area variances where, owing to special conditions, little enforcement would result in practical difficulties. So yes, you guys do have the power to make a decision. With that being said, here's a quick overview of our project. It's rear facing, it's on the second floor, straight off our main level. It's not on the roof, not on the street, and does not exist past existing lot lines. There's zero impact to public infrastructure, right-of-way, or adjacent structures. It is self-structured in its own. It doesn't bother any neighbors. It's on our own private property. The space also provides outdoor service in line with every other neighboring property in the downtown district. We believe that this project that we're talking about today is a textbook example of how HF 652 is supposed to work, and here's why. So I'm going to go through our 5 steps on how we meet the criteria. So, number 1, our project is not contrary to public interest. First of all, there is no public funding for this project. The city itself and the public receives taxable value at 0 cost. Number 2, it improves downtown vibrancy and the pedestrian experience and decreases indoor crowding. It also aligns with the goals set out by Iowa City's own strategic plan of supporting small business, outdoor dining, and economic vitality. As for the staff report, I'd like to address that. They believe that an increase in occupancy, this would increase our occupancy, which would be completely untrue. This would simply redistribute patrons throughout warmer months. Additionally, occupancy is not tied to other patios throughout the downtown district. There's no provision in the city code that automatically increases a building's occupant load based strictly on the presence of an outdoor service area, such as a sidewalk cafe or patio. Occupant loads must be calculated per code by fire and building standards, and neither Title 10 of sidewalk cafe regulations nor Title 14 of zoning provisions treat outdoor service areas as singular triggers for an increase in improved interior occupancy. Occupancy is not governed by zoning. It is done by building and fire, which we already adhere to. Additionally, Koa Cantina is already a non-conforming establishment. We've been grandfathered in, and so ADA is not a question here in our application and cannot be enforced. You can't retroactively enforce code. Lastly, there's no public safety concern for the alley. As Ann spoke to earlier, Joe's was the last one to get one of these. Joe's shares the same exact alley with us and has 2 egress exits in the same alley. Enforcing that and denying us based on that is unequal enforcement 100%. For the second part of HF 652, owing to special conditions, a literal enforcement of the code would result in practical difficulties. We fully meet the burden of enforcement of the code results in practical difficulties. Koa Cantina is entirely located on the 2nd, 3rd floor. Per the staff report, the roof cannot allow an RSA or a grade level patio. This is due to current code not addressing situations like this. This is a site-specific difficulty. Denial of this variance eliminates the possibility of outdoor service, unlike our competitors. For the third part, practical difficulties are unique to the property and not self-created. The practical difficulties arise to the building layout. We cannot have an at-grade patio or rooftop, once again reiterating that. The building also predates all code and the site conditions are historic and immutable. The building can't be modified to make a practical solution. The difficulties are not self-imposed by anything myself or my business has done due to development or remodeling. Per the staff report, prior tenants have operated in that place. That is true. No one has operated in there since 2020 when COVID took over our industry. After COVID, outdoor dining became a must. You have to have it. Like if you're a restaurant, you have to have it. All right, we're going to move on to number 4 for the 4th tier of HF 652. The spirit of the zoning provision shall be observed. City ordinance already allows outdoor dining, and denial would create an unequal playing field. As you can see per your attachment, that we are the only place without a patio. The patio does not infringe on the public right-of-way or adjacent buildings and follows all safety and fire protocols. Once again, this is also not an expansion of a liquor license. It's a seasonal accessory use just like every other patio is. The code's intent is to ensure safe and reasonable use, not to prohibit functional outdoor service areas permanently, especially in our case. And then for the 5th part, granting the variance will not significantly alter the character of the neighborhood. Well, we agree with the city that it wouldn't alter the neighborhood and would actually enhance the amenities of what downtown has to offer. So in closing, I respectfully request that the board grant us this area variance as we fully meet the criteria under HF 652. That is undeniable. The patio is modest, code compliant, and appropriate as the minimal relief set forth by awarding a variance. The difficulties in this matter are fully structural and site-specific, nothing that has been self-imposed. Denial of this would do greater harm to fairness, small business competitiveness, and economic vitality. The Board of Adjustment is fully authorized to grant this variance. Denial based on unclear or shifting terms like horizontal expansion violates both the intent of zoning code as well as state law. The practical difficulties are real and the benefits are clear, and you guys are fully empowered to grant this relief. Thank you for your time and your consideration.
All right,
if you have any questions, let me know.
Any questions from the board? Let me ask a couple of quick ones.
Yeah.
The list you've given us of drinking establishments with outdoor seating, and you list yourself as the only one not having that
Correct.
capacity.
We're the only one.
How many of these are rooftop or deck?
I did not include Joe's in there because we are a full-service kitchen as well.
Okay.
So I added that with the drinking establishments. Joe's itself does not have a kitchen, which was a requirement back in the day when they got approved.
Okay, but I'm trying to make a distinction in my mind between say the Ped Mall outdoor dining areas and a deck attached to your establishment.
It should be treated with the same logic. Sidewalk cafes do nothing to expand your occupancy or increase it. And there's no additional liquor license needed for it. If you're already a licensed establishment, you can do that. However, we're not on the grade level, so we're unable to do that.
Okay. Don't go away, because I actually have a question for staff about this issue, and you might want to respond to it. Two things. Mr. Rohrer says his license capacity is 240 and not 170.
It is.
What is the disparity here?
Our building code staff they calculated the occupancy based on the plans that they received, and they had it at 170 to 200 with the deck. Theoretically, let's say those numbers are wrong, and it is 240 currently, adding a deck would increase it above 240, and it would still be an expansion.
At 12.5%.
Okay.
Say
But-
that it were to increase.
But any deck expansion is a expansion in capacity, regardless of what the current capacity is.
Yes.
Allowed capacity
Yes.
is. When a business uses the Ped Mall for outdoor dining area, does capacity of the business itself factor in their ability to use the outdoor Ped Mall? Does that?
I don't know the answer to that.
The answer is no.
Well, that may be. I just want to make sure that we're on the same page here. So when the city grants.
Sue has an answer to your
Okay,
question.
good. I'm sorry, Sue, come on.
The Ped Mall is the use of city property. It's not the business's property.
Right.
Right. And what the capacity of the eating area, what effect that has is on bathroom uses. I think that's the only thing. You must be able to have enough bathrooms to, I don't know what the ratio is, but so many seats, so many people, you have to have a certain bathroom size. So that's how it would affect the occupancy of the Sidewalk Cafe. Is that an answer to your question?
Well, I'm trying to get clear in my mind the distinction between more people using a business on the Ped Mall
Right.
versus more people using a business such as Mr. Boris's, where the size of the current business is not a factor in increasing the number of people actually using the business if they're on the Ped Mall. Does that make sense?
I mean, thinking about it in the terms of a rooftop service area, which this is a request for,
Right.
that is an increase in occupancy. But the code says if you meet all of these criteria, you're allowed to expand. Does that make sense? The code allows for non-conforming drinking establishments to expand through the establishment of a rooftop service area, which is an increase in occupancy, but it has to meet all of these criteria. The difference here is that this is still an expansion, but it doesn't meet the criteria of a rooftop service area.
And that's why we're asking for a variance from the code. And the same logic should apply, that if I were to apply within the same city code for Sidewalk Cafe, we meet every single definition there besides the fact that we're not on the ground level.
But you're also a non-conforming use, which is a whole sort of umbrella over all of this, if I'm correct. And that's
Correct, but
And that's
the
where-
building itself is non-conforming.
The building itself is not conforming.
Correct.
Well, it sounds like that, regardless of who owns it, no expansion is allowed. Is that correct?
I mean, they would be able to expand if they could meet the criteria for a rooftop service area and get a special exception.
If it wasn't a bar, for instance, and they wanted to put an apartment on the back or something like that, would that be allowed?
That would be an expansion
Yeah.
per our definition, because you're increasing the number of bedrooms. So residential uses are allowed in that zone. So if they met the other criteria related to parking and open space, that's something that could be done. They're not going to have any parking, though, for residential.
Right.
Yeah.
And board members, if I may, counterfactuals or hypotheticals are very difficult for folks to answer, right? You have a specific set of facts and a specific set of questions in front of you, and that's the controversy that's here today. So it's good to ask clarifying questions to get your head around this and compare apples and identify what's an orange. But I would want to don't stray too far from what you have in front of you, please.
Okay. All right. Do you have some?
I have a question.
No.
Mr. Roras, how late is your restaurant open?
We're open till 9 p.m.
How late is your business open?
The business is open till bar close.
Okay, thank you. Just to clarify, and bar close is at,
It's 2 a.m. by the state. I mean, we close by like 1:30, but yeah.
thank you.
If you know this, the list you gave of other establishments with outdoor seating, and one of the issues here is you're already a non-conforming property. Do you or the staff know how many of these?
Yes, there's
businesses are
multiple
non-conforming?
non-conforming drinking establishments with patios attached. There's multiple. Joe's Place would be one. Brothers also has a patio attached to their space, and Gabe's also benefits from the same thing. All three of which have like zero kitchen. This is about dining.
Okay, but I'm talking about, are they considered non-conforming?
Everyone in the district is considered non-conforming with a 2 a.m. liquor license.
Okay. Is that true?
Yes.
Okay.
Yeah.
So is there a precedent for a beer garden or a service area on the first floor?
It's the Sidewalk Cafe, which Sue was talking about, which is in the public right-of-way.
Okay. But,
There are also, sorry, go ahead.
no, I'm just, are there any at the rear of the building?
Yes.
And if there are, how was that justified?
And I need to interject, precedent is not a thing here for you folks. There is no such thing as precedent. You have the facts in front of you. What has happened on another property is not relevant except to the fact whether it is applicable to the 5 criteria for making this decision, character of the neighborhood and such, best interest, spirit of the code, and all the rest.
Okay. I think, and I'm looking at something called the Plan Detailed Report. I think this is information that came from you about your position, where you say at the bottom of the request is the minimum necessary to provide equitable, economically viable use of the premises.
Correct.
Is it your position that without this deck, you're not economically viable?
Yeah, so if you look at my original application, all the way down, I attached a sales graph. We honestly, when the weather is nice and being the only one without a patio, we are absolutely dead. We have to wait till the sun goes down before people come into our establishment. There's a huge economic impact being the only one not having a patio.
Okay, I understand that, but is it the difference between open or close?
I would say over the warmer months, like especially when students leave, it would be worth us closing our doors than operating throughout that time period.
Okay.
This is, I'm sorry. No, you go ahead. This is a question, I think, both for the applicant and for staff. Among these businesses that are cited as having outdoor seating, a number of them are in the city right-of-way. Joseph's, Baroncini, Nodo, Mickey's, Pullman, Donnelly's. So they're allowed outdoor seating under a completely different mechanism, which is entering into an agreement with the city, following fencing regulations, making sure their lavatory counts are up to code. Is that correct?
Yeah, it's the Sidewalk Cafe permit.
I wish I knew how many of these examples are subject to that type of agreement, which is a completely
So
different
Yeah,
mechanism.
so I own Quinton's as well,
Okay.
downtown, as well as the other locations throughout the state.
Okay.
We have a sidewalk cafe there. So some of the requirements are that, you have a full menu. You operate your kitchen over 50% of the time. You have someone on site that fully prepares food, et cetera. We meet the burden for all that. I mean,
Okay.
the only difference we're debating here is, like I said, the gap in the code between the two. That's why we need a variance.
Okay. Then,
So everyone that has it out front of their building, every single one in the downtown Iowa City area is subject to the sidewalk cafe. So the exceptions would be like Gabe's that have it on their back end, Brothers, which is attached to their space, and then Joe's, obviously, and Gabe's.
yeah, if I may, Gabe's has had that outdoor service area since
Correct. Yes.
I
I'm
was a
aware.
pup.
Yeah, I'm aware.
Okay, so being that it was established a long time ago,
Yes.
it's not the same situation as what you're asking us for right now. You're asking about, you have a current situation, right? And you are asking to amend that situation in a very particular way. It's not, if you were located on the ground floor, and if there were room in the right-of-way, then perhaps the avenue of a sidewalk cafe would be one you could pursue. But it's a completely different structure, as you know, because you also own Quinton's.
Correct.
Okay? So we can't really draw an arrow between the sidewalk cafes and a rooftop service area. They're just not the same
Correct,
thing.
but they're the only things that exist within the code, and we fall in between, so we're in a gray area.
Understood. And it understood, and I understand, I hear what you're saying. I'm just hoping that you can also see that some of the examples that you're giving aren't examples that we can use to determine issues like fairness or, fairness, I will say.
But both of those things within the code reside under an outdoor service area. So we're talking about an outdoor service area, so apples to apples, it is the
Well,
same in my opinion.
If you'll excuse me, we're talking about a rooftop service area.
We're asking
And
for
that's different from an outdoor service area.
correct, but
Okay.
we're looking for a variance from the rooftop code as well as the outdoor dining.
Okay.
I have a question for the staff. Is it required that to get a patio service area outside that they have to be a ground floor establishment?
That's what the applicant has said. I am not familiar with our
Yes,
sidewalk cafe
It's
permit.
based on your storefront, so if you walk around town, you see the width of them, they're all the width of the storefront. That's what it's based on. We don't have a storefront.
I just have to say, yes, it is related to having a ground floor use, but again, it's a different, you're not applying for an outdoor service area. You're applying for a rooftop service area. It's a different thing.
I'll agree to disagree. This is a variance. We're not discussing the current code. We're looking to sidestep it. That is the point of a variance, where code has caused you practical difficulties.
Just bear with us. I want to make sure everybody has a chance to talk. Any other questions for the applicant?
And you said that non-conforming use goes with the use, not the building, correct?
It doesn't go with the business. So as long as you continue to operate a drinking establishment, it can continue to exist.
And that's established in the zoning code,
Yes.
okay? So are we being asked to amend the zoning code here?
No.
I mean, we can't.
Right.
That's not our business, all right? We're being asked.
Yeah, that has to go, that would be a different process.
Yeah. So, I mean, that's, even though the effect is the same, that would be the reason.
Your request is for this specific property.
Yeah, okay. That would be the reason that, I'm reluctant to, I think we may be out of our league here in terms of our authority.
You have the authority to approve a variance under.
Don't tell me what our authority is, okay? We do have that. We do have that. Is this within that, is your expansion rooftop service area within that definition? I don't know that. And that's why we're discussing this.
I'll just offer my opinion. I think that this is a dimensional or area limitation, and the language in the state statute says that these numerical limitations include but are not limited to the specifics that they go on to list. To me, it seems apparent that an addition, which is measured in a certain amount of square feet, and also has an impact on the number of persons that are served in that establishment, is a numerical limitation. And our Board of Adjustment is given the ability to hear a case, to hear a variance that has respect to area, dimensional, or other numerical limitations. So I think we are, yes, sir?
If I would invite the board to keep reading. The practical difficulties the property owner must be in making a beneficial use of the property allowed by the zoning ordinance. Okay? I believe staff has made an argument, and you can take or leave their argument to determine its merit, that there is a way to expand this, but there are criteria that must be met to that. So there are many other criteria that you still have to those boxes you need to check within that same paragraph. But I want to draw your attention to that one, which does not exist in the city ordinance, but does in the state. And so it applies here.
And I don't disagree with that. I agree with you. I'm not saying that the fact that it's a numerical issue is grounds for us to approve the application. I'm just saying that it falls within the realm of what we can discuss.
I think I agree that you should keep talking about that for sure. Yeah.
Okay.
I think I'm not trying to shut you down at all. I would say I just wanted to encourage you to read the whole thing.
Yes.
But yes, that is a reasonable inference you could draw from the plain language of the ordinance, I think.
That we have the
statute.
authority to hear the case and make a decision on whether to.
If you determine this is an area or dimensional or numerical thing, I would point to a number. What's the number? Is it area? How big is an expansion of the square? But when you get to findings, you'll want to have an answer for each of those things. Our finding is that it does or doesn't meet each of these criteria, and here's how it does or doesn't, right?
Okay, thank you.
Mm-hmm.
I have a question for staff. How is a rooftop service area different from an outdoor service area?
So we do have outdoor service area standards, and they don't have to be on the roof. There are other examples in our community that I know that we've received inquiries on outdoor service areas in other locations outside the downtown, like Club Car, for example. And there was one over by, I don't think it was Grizzlies, but maybe the one near Grizzlies was looking at doing an outdoor service area, and it's essentially a patio on their property. The rooftop service area is essentially above the drinking establishment on the roof. Whereas an outdoor service area is going to be also on your property, but on the ground level.
So if it's not on the roof and on a deck, what is it? Is it rooftop? Is it outdoor? Is it?
I think what we're saying is that it's not a rooftop service area because it doesn't meet the requirements of a rooftop service area, but that's what's being requested.
Does city code then allow for a non-conforming use to have other types of outdoor service areas or only the rooftop service area?
The rooftop service area, and then they can also do the sidewalk cafe, but that's not on their property.
Okay, so they don't have any allowance for any other type of outdoor service area in city code?
The ones for the downtown drinking establishments, I think the options are a rooftop service area or a sidewalk cafe.
Any questions or comments for the applicant? Thank you very much for now.
Appreciate your time. Thank you.
At this point, if there's anybody in the audience who would like to support or oppose this application, I'd like to hear from you.
Good evening, Dennis Mitchell with Midwest One Bank. Our bank is trustee of the trust that owns the building. Simply here as an interested observer, but we're supportive of the applicant's application, and so just wanted to express that.
Okay, thank you. Anybody else?
I have a question for the applicant.
Sure.
When you purchased the property, how were you made aware that it was non-conforming?
As far as the drinking establishment, I mean,
Regarding the 500-foot rule, right?
I mean, I went to college.
You
I
know about
graduated
it.
from here. Yeah, I've been in the industry. I've owned Quentin since 2012. I also managed Martini's, Formosa, all that throughout my college years, and then moved to Des Moines, opened a couple bars there, and then relocated back to Iowa City. So I'm pretty up to date on everything that happens downtown.
And does that non-conforming use, is that anywhere in the bill of sale, or were you?
No, we were actually under the impression when we purchased the Clinton Street Social Club, in the packet that they sold us on, they actually had an outdoor service area, and it turns out it happened to be Shorts that was in the parking spot. So they sold us on that. We were under the impression. I first went for a sidewalk cafe, was told I was unable to do that, so we looked at other routes, and I've honestly been working on this for over a year, going back and forth with staff.
Okay.
So, you did not recognize the limitation, or you thought you were misled?
I would say I was misled in the sale as far as the sidewalk cafe. That was the original plan to have that. And then I was told I was unable to do that because we don't have a storefront. We're located on the second, third. So we've been looking at alternative routes. Per the staff report, a rooftop is not feasible on that building. So utilizing our private property for a beneficial use of our business was our best option.
Okay, but you bought the property.
We bought the business within the property.
Bought the business with assumptions that you could do things that you could not do.
Correct. And that's why we have, obviously, the variance standard and everything else. We've been in contact for months now.
Okay, thank you.
Yep.
In the language of the variance, of a area variance, there are a number of considerations, right? Setback, distances, et cetera. It's not meant to be complete, is that it? Because this is not included in that wording.
It is not. I can't give the board a definitive answer on that. When we pass laws, then we have questions that arise from them because some parts of them might be unclear or ambiguous or applied in different ways. And then the courts will come along and issue case law to provide guidance to folks like me and folks like you about what they really meant was. I would say that it's that Ms. Tallman spoke a little bit about, while we're talking about a numerical or distance or an area thing, right? Okay, do your best to figure out what that is. I do think there is I think reasonable people can disagree on what these words necessarily mean, and I would be stunned if people don't come up with different conclusions across the state as they're trying to come up with responses to this. And I think the board here would be charged with giving effect to every word, and do your best, folks. I don't have the best answer. I don't have a straight answer I can give you for that it does or doesn't do a certain thing.
Okay, so the state law is changing tomorrow and the city code?
No, the state law has been in effect since
Okay,
July 1 of last year.
The city
Iowa
code.
City has adopted code to give effect to the changes to mirror state law. I do want to highlight that I don't believe that the city code gives effect to that language I highlighted earlier about that the beneficial use of the property must be one that's otherwise permitted by the code. That does apply here, even if it's not in the city ordinance. So that line I said about beneficial use of the property allowed by the zoning ordinance, that is a standard that needs to be applied in order to give a variance under this criteria. If you decide that all the other criteria also are satisfied, that one also needs to be satisfied too.
Mm-hmm.
I hope that's responsive to the board's question.
So the state law has been in effect for
Long time.
a long time. Do you know of any cases that have illustrated, defined, or set the standards for how that state law is to be interpreted?
None. I don't. So cases get reported at the end of the year, and they get all bunch. You may have seen the Supreme Court. All the cases are coming out in June, right? And they all get reported and they all get lumped together. I don't have any case law on this to speak to it.
Okay.
It's too soon.
Okay, all right, thank you.
I mean, the city has counsel too. If Sue is aware, you can speak to it, or the applicant. If anyone knows of any law that's controlling, would love to hear about it.
Okay, thank you.
I have another question for the applicant.
Sure, okay.
So you are saying that this isn't a rooftop service area?
Correct.
Is that
It's
correct?
just an accessory.
Is it an outside service area?
It is an outdoor service area.
Is it on the ground floor?
No, it is not.
Okay. Is it a sidewalk cafe?
No, it is
Okay.
not.
All right, thank you.
Yep. And to his point, I've done a lot of research on HF 652. So far as the state awarding it, the state has ruled in favor of the applicant 3 times.
I have another question for staff. In discussions with the applicant, did anybody talk about the difference between a bar and a restaurant as far as the open hours of operation? And if this, for instance, closed at midnight, would the applicants request for a hybrid outdoor service area even be possible? It seems to me like this, and you mentioned this, Mr. Roras, you mentioned that you fall in a gray area. You are neither a outdoor service area, you're not a sidewalk cafe, it's not a rooftop service area. And so I'm wondering if a use isn't addressed in the zoning ordinance, then the zoning ordinance needs to be, for that use to even be considered, the zoning ordinance would need to be amended. Is that correct? I mean, is what he's proposing, it's not a sidewalk cafe, it's not a rooftop service area. Does it fall outside of any of the definitions of uses that are even allowed?
Well, it would be a drinking establishment. That's what the use would be, right?
Right.
But your point about the restaurant and the closing hours, I have not discussed that with the applicant. I don't know if other staff from the city did, but that was not brought up in our conversations.
Julie,
Does that answer your question about the text amendment, though? I think,
I just want to ask Julie, how does that distinction affect this process, this discussion?
Well, drinking establishment, a non-conforming drinking establishment cannot be expanded unless it meets a really narrowly
Okay.
defined set of criteria. So if you look at the definition of what a drinking establishment is, it includes particular hours of operation and maybe even whether or not food is sold. And if this were not a drinking establishment, if this were a restaurant that didn't meet the definition of drinking establishment, then what would have happened to this application? Would we be in this position? Would he be in this position?
yeah, that would be a completely different request because it would no longer be expansion of a non-conforming use.
I have a question for staff. What, are all restaurants that serve alcohol considered drinking establishments? Or
No.
are there separate, what is the difference between a restaurant and a drinking
Yeah, an
establishment?
eating establishment closes at midnight.
That's by code? Mm-hmm. Okay. So basically, the applicant is talking about a drinking establishment after 9 p.m.
After,
The deck is a drinking
yeah, it's
establishment
just,
after 9 p.m.
it's just a drinking establishment, yeah.
Okay.
Can I comment on what you guys were discussing earlier? We did have meeting with staff Ann was not present. We did request that, if we operated on different hours, say the patio were to close at midnight, we offer that as an option. We actually had a meeting here with the city manager, city attorney, as well as the downtown district, and they were not amendable. We've also asked for an amendment. We've asked for a minor modification to the code to address it, and it's all fallen off deaf ears of just no, 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 no.
Okay, so in the discussions, you were willing to restrict the hours of operation for this
Correct.
whatever deck,
Outdoors.
outdoor
yes.
deck to
Which I'm pretty sure all sidewalk cafes as well as rooftops have to be closed by midnight.
Okay.
Unless that has been changed.
Okay. So you're willing to close at midnight, even though your kitchen closes at 9?
Correct.
Okay.
But for the outdoor portion.
Correct.
Outdoor only would close at midnight. The inside would remain open.
Oh, I understand.
Just as every other
Okay.
patio.
I have a question I'm not clear on. If this were to be built, would there be a door from the second floor?
Yeah, so we would be currently using our exit that's already in there. So I don't know if city staff even reviewed our plans, but the plans do have the same egress exit that is currently allowed by fire and building code.
one last clarification, and this is a reiteration of something we already talked about. After 9 p.m., basically, the deck is a drinking establishment.
Yeah, same with every other, 90% of the restaurants close at 10
It's
p.m.
just a drinking establishment.
Okay.
It's not at 8 a.m. or 8 p.m., it's a restaurant, and at 9 p.m., it's a drinking establishment. It is a drinking establishment.
The whole kit and caboodle.
Yes.
Okay, great, thank you.
And that's where the non-conforming comes in between 2 a.m. and midnight. So technically, every restaurant that does serve alcohol is still a drinking establishment. They just have to close by midnight because they don't have a liquor license that was approved after the 500-foot rule.
I have a question for staff. This is more or less establishing hardship, but if he were to change his use classification from drinking establishment to restaurant by changing his hours, would he then no longer be grandfathered in ADA compliance requirements?
I think the request would be completely different than what is being considered tonight.
Yeah.
We'd be talking about a completely different use and an addition to an eating establishment. So it would be completely different set of standards.
I understand that. I'm just talking about hardship and use of his, does he have other options for use? If he wanted to be able to put this, then he would have to change the classification of use to eating establishment, which would then no longer be grandfathered on the ADA. Am I correct?
The ADA requirement is for a rooftop service area. So if the request is a rear deck addition, the rooftop service area standards wouldn't apply. Again, and we're talking about,
I'm talking about.
hypothetically, he becomes an eating establishment and agrees to the hours of operation and wants to do an addition. We would review that completely differently than we're reviewing this request.
On the opposite end, what if I were to just have my kitchen open till 2 a.m.? How does that affect anything?
I don't think it would. I think that if you were open until 2 a.m., you'd be a drinking establishment, whether or not you sold booze, really.
Yeah.
Oh, well, the same logic should apply to the last city council meeting.
Sorry, I didn't mean to be flip.
I have another question. You say that this does not increase occupancy. So are you saying that if your occupancy is whatever number, it doesn't matter, 240, 170, whatever, that you cut off your occupancy at that number?
Yes, yes, we
And
do.
don't allow any other patrons specifically to go to the patio?
Correct, yes. Anytime we're busy, that standard operating procedure for fire code alone is to keep track of your capacity. We have security managers, security guys, everyone keeps account at the door, so we do not exceed our occupancy. That's what lines are for.
So with or without the deck, you're still limited to what?
Yeah, it would actually be a negative impact for the city to have the occupancy affected because then we would be able to fit more people in there.
Mr. Chair, just wanted to draw your attention to, in the packet here, 14.9A1 defines expansion, right? And an increase in the occupancy load of a building is considered an enlargement. And that's the end of the story. So that would be the question. Is there an increase in the occupancy load by making it bigger? Not whether it's, and so however that occupancy load is determined, if that number is one higher, then that's an increase, right?
But if you already have an occupancy limit,
As all buildings do, right?
right? This addition of the deck does not change the limit legally. Is that correct?
I don't know that
It does change the
I think that
limit.
it absolutely does.
Does change. Okay.
Because you got your occupancy within the building. That's one number. Now we're adding a deck which people are also going to occupy.
Okay.
That increases it.
And occupancy is based upon
Yeah.
square footage.
And the opposite end is where every other patio that's listed there for competing businesses, it makes zero effect on their occupancy.
Well,
So for Quentin's example, our occupancy doesn't change when we have a patio.
Your capacity changes for sure.
It doesn't.
Again, this is, as Sue mentioned, the Sidewalk Cafe is in the public right-of-way. It's not within the building. It's not on their property.
Okay. Any other questions for the go ahead, Julie.
Well, an increase in occupant load is only one factor in determining whether something is an expansion. There's also an increase in floor area.
An increase in what?
An increase in floor area. This is an increase in floor area. It's an expansion, whether or not it increases occupant load.
What's the definition of expansion? Like when it comes to occupancy, because it's not an enclosed area.
It's adding square footage to your business.
A seasonal accessory use, yes, but not permanent use. So for example, I wouldn't be able to use it in December or January.
Splitting hairs.
Yeah, there are outdoor service areas that have heaters that are able to stay open through the winter. Do we have I thought there was a definition in the packet of expansion.
It's page 4.
There is, yeah.
As it relates to occupancy.
The entire definition of enlargement and expansion is on page 2 of the staff report.
Okay. Thank you. An increase in the volume of the building, that would be enclosed, I believe. An increase in the area of land or building occupied by a use. This would increase the area of land, even though it'd be over it. For non-residential buildings, an increase in the occupancy load of a building is considered an enlargement or expansion. So I think that increase in occupant load is just one of, I would say, two portions of that definition. Increase of the area of land occupied by the use, regardless of whether there's an occupancy load increase. I think it would still be considered an expansion.
Thank you. Any other comments or questions from the board? Final quick comment from the applicant.
Yeah, I mean, if you review the burden of what we're looking at HF 652, we fully meet all 5 criterion, 100%, without a doubt. We're in a gray area. This is what variances are meant to serve the public for, to offer relief from current code.
Okay, great. Thank you. Any other information the board would like from staff? If not, I'm going to close the public hearing. And we need a motion for the purposes of discussion, to approve the application.
It's approving the materials. I motion to approve application VAR 260001, an application requesting an area variance for the expansion of a non-conforming drinking establishment in a CB10 zone for the property at 18.5 South Clinton Street.
All right. Second on that.
Second.
Seconded by Mark. Okay. Is this the point where we decide whether or not we should continue, that we have the power, or do we have?
I mean, there's no reason you can't decide all of those 5 criteria, and if any of them is in the negative, then you're done, right? But
that means we have a discussion of the findings of fact.
yes, I think yes.
Okay. Board discussion.
I think this is simply a use that is not permitted in the zoning ordinance. It's not described. It, as a non-conforming establishment, it is an expansion. It's not a rooftop service area. It's not a sidewalk cafe. It indeed is in a gray area that falls outside of what our zoning allows. I don't see how we can approve the variance. That's my opinion.
So therefore, what I'm hearing, Julie, is that the findings of fact is established by the staff. You agree with the findings of fact?
I do. I agree with the findings of fact by staff.
Okay.
I agree too, and we can't change code to try to make this fit. It's not kind of in this gray area, but it does fall under an increase of the area of land occupied by the use. I think a patio expands the land use, and so that's not allowed by the code. It's considered an expansion, which is not allowed by the code.
I agree. It's not within our jurisdiction to change the code. We're obligated to follow the law, and that if the code needs to be changed, that falls on zoning board, not us.
I don't think that the intention of the legislation regarding area variances, I find it hard to believe that the authors of that had in mind overriding a fundamental definition of whether or not the property is conforming or not conforming. There's nothing in the definition that suggests, I mean, these are pretty subtle things. Requirements for minimum lot size, setbacks, yard widths, things like that. Okay, this is a structure that's yet to be built, okay? It's well within, it's well within, it's not grandfathered in. It's not subject to criteria other than what I think is right in front of us, which is this use cannot be expanded. It's a non-conforming use. I think that the better avenue might be, asking for the zoning board, asking for the city council to change the zoning ordinance. We're kind of bound by that. I mean, so I would agree with the findings of fact and say, no, it's not. It's not
I would agree with the findings of fact, but I think we have to recognize, I think Julie used the word ambiguity or subtlety. There are some issues here that this board might not be the final arbiter of, based upon how we interpret these facts, how we interpret the code, how we interpret the findings of fact. Listening to the discussion tonight, I think that we are bound to deny this application. And it may be resolved somewhere else, but from our perimeter, I think we're well within our duty to support this, support the staff report. Any other discussion from the board? It's time to call for a roll call. Remember, it's a motion to
approve.
affirm it, but the staff is recommending denial. So agree with the staff, you have to say no.
Yeah.
Okay.
Roll call?
one more thing. So we're not voting on whether or not we think we have the authority.
Nope, this is just a straight up.
We are bypassing that consideration and just going to the subject at hand.
Which is
right?
perfectly fine.
Variance.
If you agree with the staff's finding, it sounds like there's a consensus about whether you agree or not with the finding of fact. The motion that's pending, I believe, is to approve the application. Is that right? And so those two things might be inconsistent with each other if staff recommends denial. So if you want to go forward with agreeing with staff's recommendation, then you would vote no here. If you that would be my read of what has just happened.
Okay.
So, roll call?
Tallman,
No.
Baker,
No.
Russo,
No.
Vandergast,
No.
Swigert.
No.
All right, thank you. The motion is declared denied, and any person desiring to appeal this decision to a court of record may do so within 30 days after this decision is filed with the city clerk's office. Thank you very much.
Would you like your menus back?
I lost my agenda. Okay. Since we get settled here. Okay,
This one will be uncomfortably warm. Okay. So.
we'll wait till Sue gets settled.
Thank you.
Thank you for your guidance.
Thank you.
This one's low.
Sue, what happened to you? You got short.
I know.
Whoa.
Grant said this was going to be a warm seat, so told me to take the other one.
Go for warmth versus depth.
Holy cow.
Okay. Next order of business is the election of officers for 2026. I guess we're open for nominations.
This is for president?
For chair.
For chair.
Chair and vice chair.
Yeah, we'll start with chair first, though. Right?
Well, based on my brief experience, you're doing a wonderful job. I nominate you.
You already determined.
Darling, let me tell you, there might be people who disagree with you.
He wants a fourth term.
No, I think I've done 2 consecutive terms. I think that's plenty for any chair at any board. I think the staff's tired of looking at me. So we need a new chair, and I'm open for nominations.
I'd like to nominate Julie because of her experience in, her the expertise that she brings to the table. That's not denying anybody else's. And if in fact you would be interested.
No,
I'd
I've stepped into that role a couple times as vice chair, and so I think Julie would do a wonderful job.
I think so.
You need a second?
Second,
Any other nominations?
I know that I'd be the natural here, but my wife isn't well. I just can't.
Yeah.
Not the natural. I just mean that,
Well,
seniority.
I think the first meeting I had, I said that I really like seniority to be a key factor. The person's been here for a while. Yeah. So,
Keeps me
no
off.
other nominations. I assume it's acclamation that Julie is the new czar of the Board of Adjustment. Do we need to take a formal vote or a voice vote or something?
Voice vote is fine.
All right. All those in favor of Julie, say aye. Aye. Vote is unanimous. For vice chair,
You want to do that anymore?
no, it would be like 3 times. Yeah. Let somebody else do it. Are you willing to do
I
it?
mean, I could handle that. I just,
just means you're never going to be
as
absent.
long as you're never absent or sick
Yeah, you say that
or
later.
have a
You really
conflict of
wanna-
interest.
No, you're nominating Mark Russo,
Yeah, I'm nominating Mark Russo.
and I will second that for sure. Any other nominations?
He's done a great job this past year.
You have. I'd like to go on record as that, maybe, I don't know when we'd say this, but I thought that your performance was stellar.
Moi? Thank you. No, I don't handle stuff like that very well because I'm basically a Freudian insecure person. Anyway, regardless of that, we need to voice vote on Mark, Vice Chair. All those in favor say aye.
Aye.
Aye, good. It's unanimous again. Y'all start
I would
next week.
recommend changing the website. I'm not sure, but I might still be vice chair for the
Oh, okay.
last year, as Mark was.
And I just want to point out to the staff, and who is this person that you had the last meeting, the new staff person?
Lisa Schroer.
Okay. I mentioned that in the future, I would very much appreciate being placed at the far end every meeting because I got real bad hearing problems, and that really helps.
Okay.
So other than that, the next order of business is the consideration of the meeting minutes for December the 10th.
I move to approve the meeting minutes of December 10th,
second.
2025.
All those in favor say aye.
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 I'm going to abstain since I wasn't here.
I have one other,
Who was the second on that? Oops, okay,
Larry.
thank you.
no, Mark.
Oh, Mark.
Larry?
I don't care.
Yeah, I'll take
Oh, I
credit.
thought it was, sorry.
Russo? Russo seconded? Or Baker?
Baker.
Baker.
Baker, okay.
No, did I second it?
That's what
I
I
thought it
heard
was-
from my right ear. It sounded like you.
I blame my hearing aid.
Moving
don't
on, I
remember
have
saying that.
I have one other item before we adjourn. I'm wondering, in the past, we used to get this list of application deadlines and meeting dates. It's just kind of handy to have as a reference. Is it possible to get this again from staff?
Yeah, it's on our website. Was it,
Print it there?
yeah, yeah.
Realize I didn't go look there.
It's on the Board of Adjustment website.
Okay.
I can send a link out if that would be helpful to the.
Sure.
Okay.
That would be great.
Yeah, that would be good.
And the only other thing I had is that these meetings are taped and broadcast. Is there a schedule for the airing or is it just happenstance? How do we find out when this particular meeting is going to show?
Yeah, I don't know. It depends on how long it takes staff to create the video and get it online. But I think they're pretty quick about it. I don't know that it's always 1 day or 2 days or, it's,
I just have an agent in Los Angeles waiting to see a copy of the meeting.
okay.
That's,
I don't get
That is-
notified. I don't get notified when it's available, so.
she doesn't. That was a little bit of BSing.
Okay.
What? Okay, that's it, folks.
Is there an extra gavel laying around that we can give Larry?
No, I don't want an extra gavel. I just want to be buried on the Ped Mall, No, I don't. No, that's too easy to locate and express different opinions. No other business.
All right. I move we adjourn.
Seconded.
All right. Thank you very much, everybody.
Third and fourth. Thank you.